Hello and welcome to Friday Live. I'm your host, Strata lawyer Amanda Farmer. It is Friday. We are heading out live via the Your Strata Property Facebook page. Hello to all our Facebookers. We're also going out to LinkedIn. We're heading out to YouTube. So good to be here with you. No, I am not in the car this week. I was just saying to the team, we had about 5 minutes where I had my bottom on the seat before we were starting. That hasn't happened at all in the last 3 weeks or so when I have been on the move, coming to you from airports, coming to you from motor vehicles. Today, I am happily here, reasonably relaxed in my home studio, ready to settle in for a decent Friday live. It's been too long, guys, and there has been a lot stacking up. Lots of news, some cases that I've been dying to share with you. Always, of course, so much going on in our Strata space. When we've got a bit more time on a Friday, I love to dive into the comments that are coming through, whether you're on LinkedIn, YouTube, Facebook. If you want to post a comment, if you want to post a hello, then I would love to acknowledge you. We have lots to discuss. Today, I've teased a little bit of that in my email that went out this afternoon. Some of you would have seen that, have a little inkling about what we're talking about today. Because I've been home this week, not on the road, not on the move, I have been catching up on a fair bit of client work, some NCAT applications getting lodged this week, lots of letter writing happening, preparing for an NCAT hearing that is now underway, part heard, meeting with new clients. That's how it goes in the weeks that I am here in the office. Love to know what you've been up to in Strata, what's been keeping you busy, and no doubt you're looking forward to your relaxing Friday evening. If you're coming in, lots of eyeballs here live. Give me a hello here in the comments, even if you're catching the replay. I always like to see those hellos coming through. Sean M, how you doing? Daryl is here saying, hey, Strata friends. Nathan, lovely to see you. Happy Friday. Donna, Georgina, Bill and Ben, how you going? Suzanne, Iggy is here. Looking forward to the discussion about training for Strata committee members. Yeah, I'm sure many of you are ready to roll on that one. We are going to get there. All in good time, my friends. All in good time. Petra is here. How you doing? Hey, Mary. Hey, Chris. Lovely to see all those hellos coming through. Definitely keep them coming. Hey, Kyria, I see your smiling face there. We're going to swing around to remind you about this week's podcast episode. If you haven't caught it yet, I do have a Strata Supreme Court case for you, case coming out of the New South Wales Supreme Court. This is one of the cases that I've had on my list that I've been dying to unpack for you, chat to you about. I know you guys love it when we go through a Strata case and just haven't had the opportunity until now. It's a case that came down in February. Some of you might be aware of it, might have been doing some reading about it already. We are going to unpack that. And absolutely, I do have access to my very own survey that I have put together for you, wanting to know your thoughts, your hopes, your dreams, your wishes, your fingers crossed for the new mandatory New South Wales Strata Committee training. What do you want to see? What would you like to be covered in this training? I'm asking you so that I can take your feedback back to government very, very soon. So I'm super excited about that. I am going to share access to that survey with you. But first of all, I am particularly excited today because it is just 2 weeks until our annual CPD event is taking place. That is our annual event that I host right here where I am in my hometown of Mudgee, Central West New South Wales. If you're not sure where Mudgee is, we are going to have about 50, more than 50 with partners and guests, Strata people descending on Mudgee in a couple of weeks' time. And I remember last year when you were all coming into town and I saw some Strata cars and I saw some Strata branding in our Mudgee country streets, and it just warmed my heart to have you all here with me. So I'm getting goosebumps just thinking about all of that happening in a couple of weeks' time. Our New South Wales Strata managers and friends joining us on Friday, the 28th of March. That's the day that my special guests and I are going to spend delivering the mandatory continuing professional development, that's CPD education, that our licensed Strata managers are required to do for the 2024-25 year in New South Wales. This is the second year that we're running the event, and it is, I'm going to say it is unofficially, you're getting the unofficial here, it is unofficially sold out. We have technically reached maximum capacity, but I am finding ways and means, as you last minute planners pop into my inbox, ways and means to squeeze in a few latecomers. Make sure you can still have a seat in the room. If you have left it to the last minute, you do want to spend the day with me, with Alison Benson of Kieran Benson Lawyers, with Bill Catharis of Spark Helmore Lawyers. Those are my special guests assisting with our teaching for the day. If you want to spend the day in a room full of Strata high achievers who are devoting their time, their focus to their Strata education right here in Mudgee, do reach out and I'll see what I can do to squeeze you in. All the details are over on the website, yourstrataproperty.com.au/CPD event is the place to go. We'll pop that one into the comments here for you. The day before our CPD event, that is Thursday, the Thursday before the Friday, I am also hosting a sold out VIP day. So that's happening the day before. I cannot wait to share what we have in store for our VIPs. It is the first time that we are hosting a day like this, and I think maybe it is a first of its kind in our Strata space. Our exclusive small group is going to be joined by Rena Van Alst and Michael Tees, our expert presenters for the day, together with me. We're going to be around the boardroom table, I'm calling it, the boardroom table at a gorgeous country homestead that we have booked out for our VIPs for the day. A super unique experience that I'm really thrilled to be bringing you. That's all I'm going to say about that for now. If you do miss out, if you can't make the dates this year, then you know I will be announcing 2025 dates for our CPD event. 2026 dates. Yep, we're already talking 2026, and tickets for 2026, I'll let you know about those. They'll be coming out shortly after this year's event. So stay tuned. We did sell out most of our tickets for 2025, sold out within the first couple of months of 2024, finishing up. So you'll want to listen up and grab those as quickly as you can. All right, heading back to those hellos. Hey, Ready Strata Management. Hey, Magda, Sue. Like if I'm pronouncing that correctly, tell me how to pronounce that correctly. If I'm not, Daryl, Strata Legends. Is that our guests who are joining us for CPD, Daryl? Those Strata Legends, I agree. Henry's asking, what's the collective noun for a group of Strata managers? It was a while ago, Henry, that I posted on the page about the collective. Oh, that's right. That's what it was. The collective noun for a group of vultures is a committee. That's all I'm going to say. Nathan is saying it is officially the best CPD event. We have a lot of people, thank you, Nathan, a lot of people returning from 2024 and bringing more of the team to the event. So while a couple of people from the office might have come last year, now we've got 5 and we've got 6 coming from the team, which I really, really love, and looking forward to seeing your team, Nathan, Daryl, Hunter Strata represented. Bill and Ben says it's a posse. It's a posse of Strata managers. I like it. Hey, Maureen. Daryl's voting for a troop of Strata managers. Bill and Ben saying it's a high caliber lineup for Mudgee. We just need a splash of sherry. Yeah, she's a busy lady. She's a busy lady. I've been following her posts on LinkedIn, and she's doing a lot. Maybe we can put some sherry on the list for 2026. Bill and Ben, I like that idea. Hey, Sean O. Jenny, hello. How you doing? Peter, hello from the Gold Coast. I hope you're drying out there, Peter. It is super hot where I am now. I don't know if it's the same around other parts of the country, but super hot. And I hope that means that our northern New South Wales, southern Queensland people are drying out. I had a few text messages with friends and colleagues this week saying, it's the moisture now we have to deal with. It's the mold and what comes from that. So we're really trying to get things dried out as quickly as we can. Totally get that. Hey, Lee, happy Friday to you. All right. So the link is there, I believe. I'll just check in with Rochelle. The link there for our Mudgee CPD event. And Rochelle, I can see that you're assisting some others who are coming into live. So Rach, if you have the link there for our Mudgee CPD event, for anyone who wants to squeeze in those last minute tickets, I'm rearranging chairs and tables and squeezing in those last minute CPD attendees. We'll get that link here in the comments for you ASAP. This week's podcast, episode 442. Yes, we are up to 442. And yes, I do have certain people asking me, Amanda, what are you doing for episode 500? That's kind of a year away. So we'll start the planning for that now. Episode 442, my chat with Rena Van Als. It's been a few weeks. Great to have Rena back onto the show. And as always, she's dropping some truth bombs. She's telling it like it is, giving us an insight into what I've described as the low morale and general sense of despair that is being experienced by our strata managers at the moment. Rena, not the only one, talking to me about that. If you've listened to episode 442, what do you think? Did you relate to what Rena was sharing? I know there's a few of you in my inbox after that episode letting me know, yes, you do relate to that. I have a few owners in my inbox saying, Amanda, totally get it. If we're getting great service, I would always be the first to compliment that service provider, whoever they may be. Unfortunately, I don't feel like we're getting great service from our strata manager right now, so I can't take you up on your suggestion there to compliment our strata manager. Absolutely. Understand some of you may be in that position. And if you saw last night, posted here on the page and over on our Instagram channel, one of the members inside our online community has had a really recent win, fantastic win for their community, where they were able to negotiate an early exit from their strata management agreement, an agreement that this person as a committee member for a while now has been feeling is not quite right, is not quite fair. We don't think that we've signed up to something that's in the best interest of all the owners here. With the help that they received inside our Q&A forum just within the first week of joining our membership, they were able to get the right words, to ask the right questions, to make the right demands perhaps of their strata manager, which very quickly resulted in that strata manager saying, you know what, don't really want to deal with this, can't really see that we're able to meet your expectations. We're happy to have an early termination of our contract. So that's now underway, and you can see those words there from that member sharing that win with gratitude here on the page. Today's podcast, this week's podcast, we also, Rena and I, had a chat about best practice when a community is raising significant funds urgently. We talked about special levies. We talked about strata loans. Did anybody else catch or love that quip from Rena? You're not paying for perfection. If you were paying for perfection, you'd be paying a lot more. And the trademark giggle after that. I love that. Tune in for that one. And I shared my prediction that the rise of payment plans, and yes, in New South Wales, we are going to see a rise of payment plans because we have new legislation coming. We're talking about that today. New legislation that is going to hit probably halfway through this year that puts some more pressure. Doesn't make it mandatory, but puts a lot of pressure on owners' corporations to offer payment plans. What's that going to mean? If payment plans are offered, if payment plans are entered into, then levies are going to be paid more slowly. Still need the money. Still need the money in the bank to do the work. We still got to pay the contractors. How are we going to pay them if we can't get the money in on time? Have a listen to this week's podcast episode. Rena talks about backup strata loans, needing to have that strata loan there waiting, ready to be drawn down if we do need to commence stage 2 of the contracted works that we've signed up for and must continue with, and we don't have the money in the bank. That's going to become more and more important. So check that one out over the weekend if you haven't yet had a listen. I know many of you. I see those eyes. I see those numbers creeping up here on the live feed. Many of you are here today, no doubt having read my email this afternoon asking for your advice about Strata committee training, letting you know that I've got a survey that I'm going to give you access to. I've got some questions that I would love to have your focus on. I do have that ready for you. I am going to give you the link in just a little bit. Just a little bit. If you can stick around to wait for that, we got lots of goodies, lots more goodness happening here today in our Friday Live. If you can't stick around to wait for that, know that the link to the survey is going to be here on the page. It's going to be here in the comments when the team is ready to post it later on this afternoon. We will also have a separate post that we will get onto the page directing you to the survey. I'm also going to email everyone again, probably tomorrow. Drop an email into your inbox giving you the link to the survey and a reminder to complete that one for you. We don't have a lot of time. I would love for that survey to be completed within the next week if you can jump on that for me, but there'll be an email. If you're on our mailing list, you'll get an email tomorrow with the link to the survey. If you're not on our mailing list and you want to do that, you've got to run now. You can't hang around for all of Amanda's teasing to wait for the survey link, then jump on our mailing list over at yourstrataproperty.com.au. That's the homepage of our website. Scroll down to the bottom and you can sign up to join our email list, and you'll get my email tomorrow with the link to complete the survey. But for now, we're going to talk about a decision that's come out of our New South Wales Supreme Court. Some of you may have done some reading on this, heard about this already. We love it when we get Supreme Court authority in Strata, in our Strata space. It's very exciting. It's not as exciting as Court of Appeal, but we really like our Supreme Courts weighing in on Strata legislation, weighing in on what it means, and clarifying what perhaps have been a few grey areas, a few question marks around, well, we think this is what this section means, but does it really? How would that be applied in practice? So it's always great to get that kind of guidance from a level that is a little bit higher than our tribunal. So the case is Coleman, Colman, and the owners of Strata Plan number 61131. We've got a link to the decision for you. There's a lot in that decision. The judge goes through quite a lot of Strata law and some helpful discussion there on various sections of our Strata legislation. What I'm going to do today is not go through every point of interest from a Strata lawyer's perspective, but I have, as I like to do for you from time to time, highlighted some of their big ticket items coming out of the case, and I'm just sharing on my screen now a copy of that case. I'm going to work through those highlights with you. So, Coleman and the owners of Strata Plan 61131, decision handed down on the 20th of February 2025. It was an appeal from the appeal panel of the New South Wales Civil and Administrative Tribunal. Let's scroll down to the facts. And, there's a reason why I share cases with you this way. I hope that it helps to understand how judgments are written, how you can read judgments to get an understanding of Strata law applied in practice. You'll see through my highlights the bits of the judgment that I feel are important, that are relevant. You'll notice that it is not a lot. It is only some few paragraphs in there. So when you see these judgments and think, oh, it's pages and pages, know that as lawyers, we are trained to, and over time, we learn how to pull out those important bits. And if you are someone who is interested in Strata law, interested in Strata cases, then the more you read, the more you will have those skills to be able to do that as well. But to the extent that I can help you to develop those skills by sharing cases in this way on our live chats, then I enjoy doing that. And from what I hear back from you, you enjoy that as well. But you've got the full copy of the case that is in our comments here. This was a case about a residential building that is in Pyrmont, Sydney, 279 Strata lots. And the plaintiff was Mr. Gary Coleman. He owned a lot in the building. The lot comprised an apartment on level 10 and a rooftop area on level 11. And the rooftop area had an eastern and western terrace. So we're kind of getting a picture in our mind. Daryl's just saying, can we get a copy of your highlighted document? I like that, Daryl. I should be able to link to that one. Leave it with me. And Rochelle, team, remind me of Daryl's request there. Good one. Section 111 of the Strata Schemes Management Act, this is New South Wales legislation, provides that a lot owner must not carry out work on the common property without proper authorisation. So this is the starting point. And 111 is a really important section to remember. It's often the place where I start as a lawyer when I'm talking about what approvals an owner may need for work. 111 says, well, you can't do it. We start from a place that you can't do it unless you have authorisation under a bylaw or under another section of the Act. So 111 is the starting point if you want to be pointing your strata manager or committee member and you want to be saying to lot owners, you can't do it without approval, whatever it may be. We start from section 111. So Mr. Coleman, together with his wife, sought approval in 2019 and 2020 to make a range of alterations to the Western Terrace in lot 147, some of which affected the common property. There was the removal and replacement of tiles and waterproofing on the western terrace of lot 147. That's really what the judgment focuses on. There's a whole range of other work and confusing things that were happening. And the tribunal, at first instance, really struggled to understand a lot of what Mr. Coleman was, I'm going to say, talking about. He was self-represented at that stage. You can see in the lower tribunal decision that there was a lot of discussion about his documents being very confused and confusing. But tribunal did its best to understand them. By the time we get to the Supreme Court, Mr. Coleman has a lawyer representing him and is able to make his arguments a little bit more clear, including narrowing down exactly what we're arguing about. So we're talking about the removal and replacement of tiles and waterproofing on the western terrace of lot 147. And the Colemans did this work without first obtaining permission from the Owners Corporation. So the Owners Corporation being the defendant in this case. So the work's been done, remove, replace tiles, deal with the waterproofing on the western terrace. We're all in furious agreement that this is interfering with the common property. Mr. Coleman goes to the tribunal and seeks an order under section 126 of the Strata Schemes Management Act that the Owners Corporation approve these works, seeking what we might call a work approval order. Some of you might be familiar with section 126. Some of you might think, hey, I didn't even know this was a thing, that we could go to the tribunal and seek approval, seek an order approving work that we've done as owners. Yeah, you can. Section 126 allows you to do that. In addition to seeking an order that the Owners Corporation approve the work that has been done, Mr. Coleman also sought damages under the Act for alleged breach by the Owners Corporation of its maintenance and repair duties. So essentially, Mr. Coleman was saying, well, I spent money fixing the common property. I think that I should be reimbursed or compensated for that money that I spent fixing the common property. Senior member Sargensen at the lowest level of the tribunal dismissed the application. And look, I'm a bit cheeky, but I've highlighted this section here in paragraph 5. This is a Supreme Court justice saying, tribunal dismissed the application. And I note that, contrary to usual practice, the decision has not been published on the New South Wales case law website. Supreme Court justice doesn't seem to realise that strata decisions coming out of the New South Wales Civil and Administrative Tribunal are very rarely published on the New South Wales case law website. And that is not for lack of the Australian College of Strata Lawyers making submissions to the President, writing letters, perhaps others, many of you write to me complaining about this, writing to the tribunal saying, please, please publish as many decisions as you can that come out of the tribunal. They are very few. I have actually colleagues of mine who write to me and say, Amanda, I heard you talking about a case that you're involved in, or a case on the podcast, or a case on the Facebook page that an owner has sent you. That sounds like it might be really helpful for my argument that I'm involved in. Can you please send me a copy? Because it's not reported. So Supreme Court seems to find that a surprising thing. Those of us who practice in this area, not so surprised that this decision was not published. Appeal to the appeal panel because Mr. Coleman doesn't like the dismissal of his application at the first instance. And the appeal panel said, we're not even going to give you leave to appeal. We're going to dismiss that appeal. We don't think there was anything wrong with Senior Member Sargenson's decision. Mr. Coleman is then able to appeal that dismissal of his appeal to the Supreme Court. That is how we end up in the Supreme Court. Now, I've skipped over a few paragraphs here to get to the nub of what we're arguing about in the Supreme Court. I've mentioned to you that Mr. Coleman went and carried out work to the common property, waterproofing, removal and replacement of tiles on the terrace. In April 2019, Coleman sent an email to the Owners Corporation. They said, we write regarding proposed work to deal with water ingress to the apartments below from the expansion joint on the roof terrace. So there's an identification here that there's a problem with the common property. We do actually have a water leak that's happening in April 2019. We're hoping to use this period of disruption. So there's an acknowledgement that the Owners Corporation is going to have to come and fix this problem, but we want to use this period of disruption to make some needed improvements to our rooftop terrace, along with dealing with aging, waterproofing and tiling and remediating the incorrect fall or slope, which currently runs rainfall towards the back of our terrace. Now, I've highlighted this. I want to draw your attention to the fact that the Colemans were doing work on their terrace at their cost at the time on their own terrace, hand in hand with remedial work that the Owners Corporation had put its hand up and said, look, we know we're responsible for this. We're going to do this. Now, I think that is common. In my experience, that is common. Strata managers, you let me know, or at least not unusual for an owner, particularly when we're talking about penthouse units. Maybe we're talking about owners in a particular building, a particular demographic, who might take the opportunity to go, you know what, I'm going to do a reno myself. I'm going to do some new things in my apartment, new kitchen, new bathroom, new flooring, because the Owners Corporation is coming in and doing some fixes anyway, and it's just a lot easier. Let's do it all at the one time, acknowledging that there's going to be noise, there's going to be disruption. Owners Corporation pay for its bit that it's responsible for. I'll pay for my bit that I'm responsible for. And I want you to know that when you hear that proposal, when that's happening in a community that you're in or you're serving, let's get some alarm bells going here, okay? Absolutely, it's legally possible to do things this way. Absolutely, it's sensible. But what you see from this case is how it can get out of hand and how it can get a bit confused and confusing when the approval for the work that the lot owner wants to do does not go through. So lot owner can't get their work approved and they need that approval. It doesn't go through. Owners Corporation is doing work anyway. Lot owner kind of sneaks in some of their work in the process. You've got to be super alert to that if that is what's happening in a building, and don't let that slide be on top of that. So that's the situation in Piermont in Mr. Coleman's building. At the time, Mr. Coleman wrote and said, look, yeah, we want to do a few things as well while the remedial work's going on with the Owners Corporation. The chair of the Strata Committee replied a few days later explaining, well, the above proposals are going to require some more expenditure by the Owners Corporation. That would need to be approved at a general meeting. And in any event, we're not a design service for you. You need to submit a formal proposal. So you want to do more things up there. I think there was a contractor who had identified that the work was more extensive than they first thought. Committees alert to that saying, well, hang on, this is a different thing. It's going to cost more money, maybe for the Owners Corporation. You're not being very clear, Mr. Coleman, about what you want to do. We're not a design service. I kind of like that line. Committee members, you might want to put that one in your pocket. We're not a design service. Send us a formal proposal. We're not going to guess at what you're going to do. Now, there was the lifting of some tiles in the course of this work, exposing a broader waterproofing problem. This is more severe than we had thought, very common with these kinds of works. The waterproofing issue is one involving the common property. That's why the Owners Corporation is covering some of the costs. And then the Colemans instructed, I believe that was the Owners Corporation's contractor, Aussie Build, to do some of this broader work. It was the kind of work that they had raised previously with the Owners Corporation, but they had not. Remember, the chairperson said, send us your proposal. They had not put in a formal works application. They had not been given approval for this more extensive work. Then there was some even more work done on top of that over the next couple of years through to 2021. Further extensive alterations were being made by the Colemans to the common property and the lot property on the terraces. We're significantly altering the rooftop terrace. We're installing a toilet on the rooftop, connecting it to the common sewerage system, replacing a kitchenette. There's lots going on here. The Colemans are doing it, and a lot of bang for their buck here over a couple of years. And no doubt it was through the evidence what was happening from the owners corporation side, what letters might have been sent, what communication is happening about this work. But indeed, it took a little while to come to the tribunal after that work was underway and had been done. Notably, however, this is one of those examples of correspondence that was happening during that time. On the 20th of January 2020, the Strata manager wrote, stating, among other things, the works formed by the Colemans had not been approved by the Owners Corporation. They went well beyond the scope of works approved to repair the expansion joint. The Owners Corporation had not been informed there were any problems or issues with the waterproofing membrane prior to commencement of the works engaged by the Colemans. The works involved an alteration of common property. Colemans need to reinstate the waterproofing membrane that had been removed as soon as possible, and the Strata Committee has concerns about aspects of the works being proposed. Now, bear in mind, the Supreme Court judge here saying that this is notable that this email was sent. Good on you, Strata manager, right? I'm not sure if their name's in here. If it was somebody here, let me know. Good on you, Strata manager, for being on top of this. This kind of thing, music to a lawyer's ears. The lawyers acting for this owners corporation, great. So glad that you were writing this correspondence. So glad that you were telling the Colemans, oh, what's going on here? This is not approved and we have serious concerns about this. It makes it hard for a lot owners to then turn around later and say, oh, I thought I had approval. Well, now I want money. I want money for doing the work. All of this becomes relevant down the track. So the tribunal rejected the claim that all or most of the works for which orders and compensation were sought was simply just a domino effect of the works that the owners corporation had approved. Tribunal was satisfied that the applicant decided to have the waterproofing membrane replaced and all tiles removed and replaced as part of the applicant's, that's the lot owners, intention to renovate the area as set out in the emails of Mr. and Mrs. Coleman in that period. They were writing to the owners corporation saying, this is what we're going to do. This is our intention with this work. And they just went ahead and did it. Didn't get approval for that. So Supreme Court looks at this challenge to the tribunal's decision. The Colemans say they weren't happy with how the tribunal dealt with this, saying, look, not our problem. You're not going to get your work approval order and you're not going to get your damages claim. You can see here what I mean when I say not all these paragraphs are relevant. We're skipping to the highlights here. In the proceedings in the tribunal, Mr. Coleman had sought an order under section 126. I mentioned this order earlier. This is the work approval order. It's essentially retrospective approval of work that's already been done by an owner. That's the order that they sought for the works that were identified in the application. Now, the tribunal was thinking about the section 126, and section 126 actually says, I won't pull it up for you, but it says, if the owners corporation has unreasonably refused to approve this work retrospectively, then 126 allows the owner to go to the tribunal and seek an order. So there was a real question around, well, hang on a sec, did the owners corporation unreasonably refuse this? Were they asked? Was an application made? Was there a meeting resolution? Can there be an unreasonable refusal if there was never actually an application or a meeting resolution saying no? So the tribunal had to look at, has there been sufficient ground for a 126 order? And the tribunal said, if the work in question requires a resolution of the owners corporation to be passed at a general meeting, so is it minor work? You need a resolution under 110. Is it alterations, improvements, enhancements of the common property? You need a resolution, special resolution under 108. Then the refusal is going to occur when the motion is not passed at a general meeting. You can't just have correspondence between the lot owner and the strata committee or the lot owner and the strata manager and a failure to respond to that correspondence. So the tribunal member, Senior Member Sargensen, said, I don't think there's been a refusal here under 126 because there was no meeting resolution. And for this work, dealing with waterproofing, tiling, this work actually needed a special resolution. There was nothing put to a general meeting, so how could it have been unreasonably refused? So very interesting approach there. And the Supreme Court kind of, in this case, likes that, but later hints that there might be situations where it shouldn't be up to an owner to wait for a meeting. And we'll get to some of those situations. So Mr. Coleman said, no, I don't like that reasoning of the tribunal. This is a case where the defendant, the owners corporation, has constructively refused its consent. It's neither rejected nor approved my application to do this work. It kind of just went into limbo. Nothing really happened. I think that's a constructive refusal. And some lot owners there, owners who are listening, may be applying this to your situation where you have a renovation application. It's taking months. Do you really have to wait for the next AGM to be able to get this through? Listen up to what the Supreme Court has to say. So Supreme Court goes through and has a look at Section 126. What are the requirements to get this work approval order? And the Supreme Court ultimately says this. The relevant works were appropriately understood as alterations to the common property. We needed Section 108 approval. That being so, the work was required to be authorised by special resolution at a general meeting, together with a bylaw. So Mr. Coleman was putting forward a bylaw or two. I haven't got into the bylaw complications. Consistent with the construction of Section 126 that the tribunal applied, the tribunal could not make the order, was not empowered to make the order that Mr. Coleman sought under 126 unless he had sought approval from the owners corporation by way of special resolution, because that's what Section 108 requires. However, it's possible, says the Supreme Court, that the application for approval is urgent, but the Strata Committee and the Strata Secretary are refusing to convene a general meeting to consider the issue, or they're declining to do so within a reasonable time, or they accidentally omit it from the agenda of the AGM. In those circumstances, as far as the owner in question is concerned, there may have meaningfully been a refusal of approval, in the sense that approval has not been given within the time reasonably expected for the taking of the decision in question. The owners corporation might say, for example, well, the owner can put it on the agenda of the AGM in 9 months' time. Yet that would be of bleak comfort to a lot owner with a leaking roof, desperate to have it repaired, in circumstances where the proposed work don't involve alterations such that they could not be reasonably characterized as only repairs. So what the Supreme Court is doing here is drawing a distinction between alterations, improvements, enhancements, additions to the common property by a lot owner. We can't approve those unless we have a Section 108 special resolution. The law is clear about that. We need to have a meeting. But what about the owner who just wants something repaired? Owners corporation responsibility, Section 106, duty to properly repair and maintain the common property. Does that owner have to put a motion forward and wait for a general meeting to be convened and have that refused at a meeting before they can go to the tribunal and seek appropriate orders? Supreme Court is saying no. For something like that are only repairs, then no. The owner should not have to wait for that resolution to be refused before their rights for to claim relief in the tribunal, to claim an order from the tribunal, can be exercised. So Supreme Court says, well, in this way, Mr. Coleman's right, that in some cases there could be constructive refusal of consent, even though no formal decision has been taken by the owners corporation, but it's not necessary to deal with that here. He's obviously doing major work. It needed a Section 108 approval. He didn't formally seek that. He can't come now and say that the retrospective approval has been unreasonably refused. So that's an important point. I can see some lot owners relying on those words there from a higher authority in the tribunal now to be able to say, well, hey, we've got the Supreme Court case that says I don't have to wait for an owners corporation to say no if I'm in that kind of a circumstance. Remember that Mr. Coleman was also seeking damages. He was also seeking compensation, the money that he'd spent on dealing with these works. What did the Supreme Court have to say about that? I believe we're going to get to that. I'm not sure if it's this paragraph. Let's see what this paragraph has to say. The need for approval of work, even if given retrospectively, is an important part of the way in which the Act balances the rights and interests of lot owners and owners corporations. That being so, to construe Section 106(5), which is the damages section, and Section 232, we think maybe is a basis for compensation as well, to say that those sections permit recovery of costs of works that have not been approved would undermine that statutory imperative. So there's the Supreme Court saying, nah, not going to give it to you, mate. You're not going to get compensation. You're not going to be reimbursed for money that you spent doing work on the common property where that work has not been approved. That would not be coherent with the Act, when the Act has a very clear regime about how work is approved and a very clear process to follow when you can't get that approval or the work is not being done. The process to follow is not go and do the work yourself and think that you're going to be reimbursed or paid for that work. And there are some other cases that come to similar conclusions in our strata space. So in short, Supreme Court has said, so far as damages or compensation can be claimed under Section 1065 or other provisions of the Act for work undertaken by a lot owner to repair common property, they cannot be claimed for work that have not been approved in the required manner. Either approval before or you get that 126 work approval after. Either get it approved by the owners corporation or get it approved by the tribunal. If you do get that approval, you probably can. That's what I'm reading between the lines here. You probably can claim those costs, but no such approval was granted to Mr. Coleman to undertake the relevant works. Given that fact, he cannot claim the cost of undertaking these works pursuant to Section 1065 and the tribunal. Senior Member Sarginson, you got it right. First time around, no error in that holding. So that is the Coleman case. Thank you very much. You've all been, I can see those eyes there. You've all been tuned in to that one. Interesting one. There's a bit more in that case, which in the interest of time, I'm not going to unpack for you right now, but do go over and have a read of it. I think I saw right back, I've seen a lot of comments come through here, but I think I saw right back, Luke was saying, great read, that case. So you're obviously across that one, Luke. Scrolling on down, Luke is also saying it's interesting to contemplate the impact of the recent changes to the Strata Schemes Management Act that will override this. Let me know which ones you're talking about there, Luke. Chu is saying, last time I ran case law, they only published 2 cases in the year 2024. From NCAT, yeah, maybe. Suzanne saying we're going through the same thing at the moment, taking too long to agree by all. Henry saying, would any aspect of planning law override strata law? If the works carried out did have council or planning approval, even retrospectively, wouldn't this approval override the strata bylaws? Yeah, but here's the thing, Henry. You're right that an owners corporation may be unreasonable in refusing work that the council has otherwise approved and permits, and you've got all your planning approvals, but the Colemans didn't even get so far as to properly ask the owners corporation for its approval. So even if they had all those planning conditions, you still need to put that application to the owners corporation to get your separate strata approval. But you're right, if strata refuses, the owners corporation or body corporate refuses that approval, they may be unreasonable because otherwise all your ducks are in a row. Strata manager wasn't named in that decision. Yeah, if anyone knows who that was, please let me know. Kyria saying, what's a meaningful period to rectify leaking or breakdown of waterproofing in a bathroom that may be causing damage to new flooring? Well, here's the thing, Kyria. Something I didn't see in the case, and yes, I was skimming through it quite quick to make sure that I had time to digest it and share it with you here today. But it didn't mention that in Section 232, there is actually a time period. If an owner's corporation fails to exercise a function and within 28 days, 2 months, not 28 days, 2 months of being asked to exercise the function, then they are taken not to have exercised that function. So if they say, no, we won't repair the property, or you've asked them to repair the property, the common property, and 2 months has passed and they've done nothing, then 232 does allow you to draw the conclusion, the legal conclusion, that the owner's corporation has failed to exercise a function. Don't think Supreme Court grapples with that one in this case. Strictly not relevant because we're not talking about repair and maintenance work, which is a function of the owner's corporation. We're talking about enhancements and improvements to the common property. Okay, so that is the Coleman case. Take that one home, guys. Enjoy that for your weekend. It is time. It is time. Thank you, those of you who have been waiting patiently for the link to the Strata Committee training survey. It is your time. And you've learned a few things along the way, right? Learned about these repair and maintenance duties and Section 126 orders, all value here on a Friday afternoon. So many of you have been asking me since the draft legislation was out, the Strata Schemes Legislation Amendment Bill 2024, which is now 2025 Act. Since that came out and we were alerted to the government's proposal to introduce mandatory Strata Committee training, you've all been at me saying, Amanda, do you know about this? What's happening? What's the training? Who's going to do it? How's it going to be done? Where is it going to be done? Is it going to be online? Is it going to be in person? How much is it going to cost? Are you going to do it? Yep. You've been asking me all of these things in email, face-to-face, members in our forum. Amanda, have you got any updates about that? All we know so far is that commencing in mid-2025, this law has now been made. We're told it will commence in mid-2025. I'll let you know if that's going to change. Section 37 of the Strata Schemes Management Act will change. It has been amended to add a requirement for each member of a strata committee to complete the training prescribed by the regulations. That's what new Section 37 is going to say. This law has been made. This is how it's going to commence. Each member of a strata committee must complete training prescribed by the regulations. Committee member who fails to complete the required training ceases to be a member of the strata committee. That's in the law. And there will be a provision for notices to be issued to those who haven't done their training, reminding them, giving them a warning, reminding of their requirement, giving them a last chance to get their training done. So that's the law. All the law says is strata committees, members will need to complete training. Training will be prescribed by the regulations. We don't yet know. We don't have draft regulations yet. We don't yet know what this training is going to look like. However, I have been with you at my back, with you being the wind in my sails. I have been in regular contact with those at New South Wales Fair Trading and Regulatory Services who are responsible for producing these regulations that are going to put some flesh on these training requirements. And next week, I will be meeting with them. Now, I want to make sure that they are armed with as much information as possible about this topic to help them make a good decision around this mandatory legal requirement. I want them to know what you are thinking. I want them to know in an organized fashion, not through emails in my inbox and messages in my messenger and text messages and conversations, in an organized fashion, what it is that you are hoping to see. So to that end, I have prepared a survey, and I would love for as many of you as possible to complete this survey, all about what you want to see, asking you what you want to see from a strata committee training program. I'm calling it. We don't know if that's what it's going to look like, but what do you want to see? If there is to be mandatory prescribed training for strata committee members, what do you want that to look like? Now, we're going to drop the link to the survey here in the comments. I think that one has gone in now. As I said, we'll put another post on the page probably over the weekend, directing you to the survey. We don't have a lot of time. I would love for you to complete this within the next week. Would be fantastic. Next 7 days. It'll take you no more than about 10 minutes to complete, depending on how much detail you want to give me. And there's lots of space in there for you to let me know everything that's on your mind. You can remain anonymous doing this survey. If you do want to share more and give me your contact details, there's an opportunity for you to do that. That is completely obligation free. To be super clear, I hope this is super clear. This is my survey. This has my name on it. This is not a New South Wales government survey, but I know that government will be interested in these results, and I will be bringing them to my meeting next week. Knowing how large this audience is, knowing the value in the information and the responses that you bring, if you promise to take this survey, I promise to share the results in my meeting next week, and I know that they will be valued by government. And of course, I'm going to let you know what the key takeaways are from this survey. We're going to crunch the numbers. We're going to do the data. We're going to apply all of our magic to these survey results, and I will be letting you know what we come up with from your comments, your answers here in this survey. I will also email this link to the survey to you probably tomorrow, if I can get the team on board to do that for me tomorrow. Get an email out with this link to the survey. If you want to get this by email, or you just want to get my emails inviting you to these kinds of events, inviting you to tune into the podcast and to our resources and any webinars that we might be having, please do make sure that you're on our email database. You can do that over on our website, yourstrataproperty.com.au. Scroll down to the bottom, you'll see the opportunity to sign up to our mailing list. But for now, you've got that link. It's not even 5 o'clock. I'll put the link in there for you in the comments to the survey prepared by me asking you to answer these questions about what you would like to see. And if you're not in New South Wales, let us know. Let us know from your perspective. It's directed towards Strata committee members. There is the option there for you to let me know if you're not a committee member, if you're a Strata manager. I want to hear from you as well. And if you're not in New South Wales, it's still absolutely applicable to you. If you were going to see this kind of training in your state, what would you like to see? All right. Kristen saying, wow, thank you for putting the survey together. Fantastic. Thank you very much, Kristen. Bill and Ben saying, might be interesting to see if there is specific training for large strata, given the extra quirks that come from being large. Bill and Ben, please put that into the survey. There's the opportunity there for you to give me long responses to some of those questions. So let me know if you tick that box. No, if none of those options apply and you tick other, please let me know why you're ticking that. We want as much information as we can gather. Okay, Jan is saying this will stop a lot of owners going on committees. I've heard that a lot, Jan. If that's how you feel, please put that. Please put that in your survey comments. Henry saying, I wish the training requirement would apply in Victoria. Victorian strata laws are so far behind. Yep. Well, I think Victoria just, not just a few months ago, and I talked about this here, Henry, at the time, just adopted our short-term letting laws that came in 2021. So 1, 2, 3, 4, 5, maybe in 4 years. 4 years' time, Henry, you might get some committee training. Mary saying, learnt a lot from that case. Thank you. Awesome. Great to hear, Mary. Suzanne also learnt a lot. Curious saying, will that be retrospective or only new strata committees that begin after commencement of the law? So the law will start, and if you are a strata committee member at the time the law starts, then you will be required to do the training. I expect there may be a time frame around that. So maybe, within the next 12 months or within the year of your service, or I suppose if we figure that some committee members are about to be voted out at the next AGM, good point, Kyria. I think there probably may need to be some timing around that. We will see. We will see. And I would love that comment in the survey. So you guys think of these things that are really practical, that government's not always thinking about. Strata managers, you're thinking about practical things. So please put those thoughts down in those comment sections in the survey. Okay. Lots more comments there. There's been lots of you tuning in. If you have the survey and you have that link, feel free to share that link. That is an open link. It's a SurveyMonkey software that we are using. So you can take that link, send it on to your communities if you're a strata manager, to your committee members. As I said, I will have an email for you all tomorrow. So if you want to wait for that, and then feel free to forward on the email. We want to encourage as many people in strata as possible to complete this survey. If you loved what you heard today, if you enjoyed hearing about the Coleman case and you would like your friends, your colleagues, your clients to be able to tap into and tune into this kind of education, then the best thing you can do is give us a little like, give us a love heart here on the stream, the feed, and that just gives Facebook all of that nice juice to be able to share this content and share this video far and wide to those who need to be seeing it. You can hit the share button to share this into your own groups and your own community groups. This is what we do here. This is what we do, is arm you with knowledge, because it was said in the post earlier today, and I think I saw a comment maybe on the website that said the same thing. Knowledge is power. Knowledge is power in strata, and if you can access that, then you can all be living, we can all be living more peacefully and more profitably for our investors, not even for our investors, for our homeowners who have their most important investment in a strata building. We all want to live more profitably in strata. All right, I'm going to come back around to those comments. Love to read those and hear what is on your mind, but for now, that is all. Thank you very much for joining me here on Friday. Take the survey. I'll be around to remind you about that. And I'll look forward to catching up with you all next time. Bye for now.